Thank you all. The topic of today's conference has literally been torn from the headlines of the recent days. The media has been full of stories about additional torture memos, about the President's contemplation of restarting the military commissions, about Congress's opposition to relocating Guantanamo detainees in the United States, and most recently about the appointment of a special prosecutor to consider and to investigate CIA alleged acts of torture. These are among the issues that will be debated during the course of the conference today. This is the third conference on this general topic that we have hosted here at Case Western Reserve. In 2005, the school hosted a conference called Torture and the War on Terror, which produced the Cleveland Principles, a document signed by over 300 experts and circulated to Congress about the treatment of terrorist detainees. In 2007, we co-hosted with the International Committee of the Red Cross an experts meeting on security detention, which produced a report widely circulated within the government and the United Nations. We are especially proud of the work of our International Law Center and the Journal of International Law in this area, and more broadly in the general areas of war crimes prosecution and human rights. This was all kicked off by a generous gift 8 years ago from alumnus Bruce Klatsky. Cox Center Director Michael Scharf and the other members of the program committee, Mike Newton from Vanderbilt and Scott Silliman from Duke, have assembled an extraordinary lineup of speakers for today. They come from government, international organizations, human rights groups, and the Academy, and they represent all sides of the spectrum of debate on the various issues that are implicated. Today's sessions are being held in a uniquely exciting format. With the exception of the General's remarks, which will follow shortly, each session will be a roundtable discussion in a crossfire format. Following the questions of the expert moderators, which will include our own professors Strassfeld and Katz, there will be plenty of time for audience participation, Q&A, and so forth. Today's conference is being webcast live, and we expect an audience around the world of 500 or more. Articles that will be generated from the conference will be published in a special double issue of our Journal of International Law, which, thanks to the generosity of the Wolf Family Foundation, will be provided to 2,000 experts and policymakers later this year. I think, to make a long story short, that our audience, but also our distinguished speakers, have a lot to look forward to during the course of the day. It's now my pleasure to officially declare the conference open and to turn proceedings back over to Michael Scharf. Michael?
Thank you so much, Bob. There were numerous co-sponsoring organizations that came together to advertise this event and whose members are watching it around the world, and they're listed in the program. It would take me a while to list them all. I do want to thank again the Wolf Family Foundation, who gave us a very generous grant that allowed us to bring so many speakers in and to publish our proceedings. On Wednesday, we had a special tribute to one of our own professors who passed away very recently, who was one of our greatest lights, Henry King, a former Nuremberg prosecutor, who, if he were here today, would be playing a big role in this conference. And I thought it would be appropriate to read to you today one of his favorite quotes from the movie Judgment at Nuremberg, which I think captures the theme of this conference and the theme of what it means to be an American in the aftermath of 9/11 with the kinds of challenges that combating terrorism faces. This quote is from the movie. It was the final judgment by the judge being rendered in court. Those of you who've seen the movie will recognize it. It actually is drawn from the actual Nuremberg proceedings and those that Henry himself were involved in. So Spencer Tracy, the judge, and I'm even going to do a Spencer Tracy imitation to kick things off. He starts out by saying, Herr Rolf further asserts that the defendant Janning was an extraordinary jurist who was acting in what he thought to be the best interests of his country. But this trial has shown that under the stress of a national crisis, ordinary men, even able and extraordinary men, can delude themselves into the commission of crimes and atrocities. How easily that can happen. There are those in our own country today, too, who speak of the protection of the country, of survival. The answer to that is survival as what? A country isn't a rock, and it isn't an extension of oneself. It's what it stands for. It's what it stands for when standing for something is the most difficult. And I think that really is the theme that we're going to be struggling with in our roundtable discussions. Before we begin with our keynote, I do want to bring two people up who are one of the co-sponsors of this. It's Michael Kelly, who's the new president of the International Association of Penal Law, and this is serving as their annual meeting, and Larry May, who won last year's Book of the Year award, given right here, who chaired the committee to pick a new Book of the Year award, and we're very anxious to find out who the winners of that are. So if the two of you would come up.
For those of you who aren't familiar with it, the International Association of Penal Law is a Paris-based organization that's been around since 1924. It's a group of international criminal law scholars, judges, attorneys. It's based in Paris. Its official name is l'Association Internationale du Droit Pénal. Everything sounds better in French, doesn't it? Michael Scharf has led this organization for almost 10 years now. He took over from the eminent Sharif Bassiouni, who together with Ed Wise got the U.S. national chapter up and running. And so I want to take this opportunity to thank Michael as the outgoing president for the tremendous work that he did keeping this organization going and starting the blog that I put up on the screen here and really reinvigorating our chapter. Michael and I will be leading the American delegation to the 5-year Congress of the AIDP in Istanbul next week. And we're going to be spending a week debating and discussing the ins and outs of universal jurisdiction, and I think it will be a very interesting time. So thank you, Michael, for bringing this organization along. Incidentally, for those of you who are interested in joining, I have membership forms, and those are available also out on the main table. And for those of you who are interested in blogging on matters of international criminal law, even as a guest blogger, you don't have to be a member, come to our blog site. You see Mark Drumble just put something up there on the meltdown in Cambodia that's going on. And if you're interested in that, please contact me or Greg McNeil. Greg, can you wave your hand? Greg is a professor at Penn State Law School, and he's also the moderator for the blog. He freely issues passwords for you to come join us on our merry electronic universe.
I freely take them away, too.
So if you're interested in that, please contact us. And now I will bring Larry May to the podium, and we will present our annual Book of the Year award. Larry?
So it was an honor to be asked, or volunteered to do this, to read the books for this year's prize. I just want to say a few words about the runner-up and also the winner this year. I don't want to hold you all from our important work, but I just want to say a few words. The runner-up book this year is Ellen Podger and Roger Clark's book, Understanding International Law, 2nd edition, published by LexisNexis through the auspices of Matthew Bender and Company. The book is an excellent introduction to all aspects of international law, and it also focuses on several often neglected topics, such as money laundering and computer crimes. Despite being an introductory text, an excellent one at that, I found the book engaging and quite informative. The book looks like this, in case you want to go out and get a copy for yourselves. And then what we've all been waiting for is this year's winner. The winner of the 2009 book prize is Michael Newton and Michael Scharf's book, Enemy of the State, The Trial and Execution of Saddam Hussein. This book was published by St. Martin's Press. Those of us who attended last year's meeting were given a complimentary copy of this wonderful book. This is sort of like the Academy Awards, you know, trying to influence us in our voting in the next year's election. Nonetheless, one of my hats is that I'm also a professor of ethics, so of course it couldn't really unduly influence me, and that's why I was put in this position. The book is an amazing combination of gripping journalism and superb scholarship. Like Scharf's previous book on the Yugoslav tribunal, Balkan Justice, it is as clear and powerful as a novel. Like the scholarly articles Newton and Scharf have produced in abundance, the book also provides detailed legal analysis of the Saddam trial. I was especially impressed with the balanced and especially critical perspective that the two Michaels took toward a trial that they had helped craft. And I was also in awe of the ability to blend legal scholarship, history, and journalism in a way that should appeal to many audiences. Despite disagreeing with many of what Newton and Scharf say about the Saddam trial, I nonetheless recommend the book to you all as the best book of this year in international criminal law. The book looks like this, in case you want to go out and get a copy if you haven't already been given one by the Michaels. And so let me now present plaques to the two winners. First, Michael Newton. You need to stay here and let them take a picture. Oh. Okay, there we go.
Yeah, she already had my best
I can
side.
see it. And then, as if he doesn't need any more things for his wall, this is for Michael Scharf.
Thank you, guys. Thank you, Mike. Wow. All right, well, if you haven't seen enough of Michael Newton already, I'm going to ask him to come back up because he's going to do a very special introduction to our keynote speech. And he was instrumental to getting the general here, as well as Sandy Hodgkinson. And we're so happy to have you here, General. Thank you. So, Mike, would you please introduce our keynote speaker? Wait, I need to forward this. Mike, oh, okay. Just a second, we're having AV problems. I am trying to get, there we go, get this one on. And what I'd like to do, maybe if the AV guys can help me, I want to get rid of all the blog stuff and just have the big picture. Oh, there you are. Can you real quickly fix that? And then we'll get you started. Okay. Oh, no, we want the next picture. I'm sorry. There we go. All right, and I'm going to bring this down so that it's not in your way, and we're good. Okay, go ahead.
We do have an overflow room, right?
Yeah, thank you for remembering that.
Yeah, it's just, I want to also recognize, of course, that we've got the overflow room, and we're of course webcasting, but also there are a number of people out in the overflow room, and we look forward to meeting and talking to some of you on the break. It's an especial privilege to be here this morning among so many friends and so many colleagues and so many people that we respect and so many people that have just wandered in from the community to participate. It's a great joy to be here, and I, like many other people here, turned down other engagements and prioritized this because of this special collection. So we very much look forward to the day. In particular, it's an especial pleasure to be here to introduce, for those of you who don't know him and don't know his record, Major General John Altenburg. Who will in just a few minutes begin our keynote speech, and with whom I have served, and on more than a couple of occasions, been disciplined a bit, been instructed just a bit, and the key is from whom I've learned a great deal. There's a bio in the program documents. It's the very first one by alphabetization. But it doesn't come near to capturing the essence of the man, the plain words on text. You can see he's currently serving at Greenberg-Traurig, had an extremely distinguished military career in so many ways. One of the hallmarks of that was, of course, service in Vietnam, wearing a Special Forces tab, a number of decorations. But he also served as Staff Judge Advocate of 18th Airborne Corps at an important period of that Corps' operational history. There's many, many stories and many people with whom we served in Desert Storm that have many stories and many memories of General Altenburg. And then, of course, we did Haiti. There's a story during the Haiti operation which you can ask his blushing bride, possibly apocryphal, but very illuminating. The story was told that during the Haiti operation, Mrs. Altenburg said to General Shelton, "I very much enjoyed seeing you on CNN." And of course, if you knew General Shelton, you can sort of relate to this with this booming North Carolina baritone. You know, he sort of puffs that chest and he says, "Yes, of course you enjoyed seeing me on CNN." And her answer was, "Yes, because every time I looked across your shoulder, I could see my husband, your lawyer, right behind you." And that's pretty indicative of the kind of man and the kind of soldier and the kind of scholar and the kind of lawyer that General Altenburg is. That's the character and the professionalism that he brought to the position as convening authority for the military commissions. And in fact, for a soldier like this to get the order from the commander-in-chief, do what you can do to conduct full and fair tribunals, that's a binding legal order. And a soldier of this character then implements that order to the best of his ability. John Altenburg's a soldier at heart. I was reminded recently in thinking about this, it's funny how things happen just almost by fortuity. I was asked to do this introduction, and then I just in random found something in my files that happened to coincide. And this is what I found. To me, this captures the essence of what General Altenburg's all about. It says, "The manager administers, but the leader innovates. The manager maintains, but the leader develops. The manager relies on systems. The leader relies on people. The manager counts on control. The leader counts on trust. The manager does things right. The leader does the right thing." Leaders, of course, are those people that we would follow into battle. Managers are the people we would follow into budget meetings. Ladies and gentlemen, I give you a leader of the First Order, a lawyer of the First Order, and perhaps more importantly, one of the finest human beings that you'll ever be privileged to meet and privileged to listen to, Major General John Altenburg.
Thanks, everybody. Michael, too much, but thank you. If my mother were alive, she'd be very proud. And I assure you, even with my wife in the audience, she would be the only one that would believe that. I want to thank Professor Scharf and Dean Rawlings and all the people at Case Western who have been so hospitable. It's been a great time already for my wife and I, and we look forward to the rest of the day and this evening. I'm reminded at times like this, when people are looking at the clock and they're wondering what's going to happen, of the fact that of our 5 children, the youngest of whom is almost 26 now, Molly, when she was a sophomore in high school, was studying Shakespeare. And of course, most of us know that in the sophomore year at most high schools in this country, we studied Julius Caesar. Molly went on to be an English major in college, and one of her real strong suits is her writing ability. She has a very crisp style. And her book report for Julius Caesar is somehow related to my presence here before you as a military man. Her book report on the Shakespearean play Julius Caesar consisted of 4 sentences. And those sentences were, Julius Caesar was a great general officer. He won many battles. He gave long speeches. They killed him. So I won't be giving you a long speech because I don't want to get killed. And also because my most severe critic is sitting right here. The juxtaposition of this conference, 8 years exactly after the events of 9/11, after the attacks, as the dean correctly stated, is welcome. It's welcome because they didn't get it right in 2001, and especially in the couple of years thereafter. and I want to talk about that as a setting for what we hope to accomplish today. I know that all the participants today hope to maybe chart a way forward, by looking back first and then talking about the various issues, and hope that that in some small way this conference can help the people that are in charge, the people in the administration, make the decisions that they need to make. Among the things that have bothered me personally over the years of watching these debates and these discussions is the failure to agree to certain terms and the problem with confluence of issues. And so kind of a caveat that I state anytime that I talk about commissions generally is to be wary of mixing issues together. An issue is war. Are we at war? Okay, we can talk about that. An issue that flows from that is detention policy, who detainees are, how we describe them. And that's where we start to get slippery as we start to debate issues, because detention policy starts to slide into commissions. They're absolutely unrelated. They have nothing to do with each other. For example, when I was the appointing authority at Guantanamo, in charge of deciding which cases went to trial, which ones were capital and the like, and actually trying to affect some of the procedures, I had nothing to do with detention policy. The only cases I was responsible for, and at the time there were over 700 detainees down there in 2004, my sole responsibility were those that had come out of the White House as a determination, reason to believe there's enough charges here, and the prosecutor sending them forward and requesting that I refer cases to trial. So at the most, at one time, I was responsible for reviewing and considering and making determinations about approximately 25 people, not 750. And yet, I'd go to discussions with people, and they'd want to be talking about everybody else down there, which had nothing to do with commissions, potentially commissions, but not necessarily at that time. And then when you crank into detention policy and whether we should detain and how detain, you crank in interrogation policy, then that complicates it even more. Now, each of these topics is important. Each of these topics needs to be discussed, debated thoroughly. But when we mix them together, we start to confuse principles. It's my view that the previous administration made three significant mistakes. They made lots of mistakes, but most of the mistakes flowed from those three basic mistakes. The first mistake was an absolute failure of public education and public diplomacy. And there are many reasons for that, and that topic in and of itself perhaps would be a fruitful discussion. Not today, because it really doesn't make any difference. The fact is they made the mistakes. They didn't educate the public, for example, about war. Are we at war? Now, I know that there are some in the room that don't think we're at war, and I, for one, would never use the expression the global war on terrorism. To me, it's meaningless. And you can imagine as a government employee, when people were leaving the organization, I would be given some kind of paperwork to give an award or a certificate of achievement for someone's 2 years of dedicated duty as a paralegal or as a lawyer working for the defense or working for the prosecution or working for me in the office of the appointing authority. And these kinds of documents, of course, are pretty much boilerplate. They did this, they did that, and it was in the global war on terror. And if it said the global war on terror, I struck it out and sent it back and refused to sign any document that had the words global war on terror. So I'd say it was a war against our enemy, the war against Al-Qaeda, the war against something, but it could never say a global war on terror because terror is a tactic and it's silly to use a term like that. And probably nobody in the room disagrees with that, but there are people who disagree with are we at war. And I would say that you may be able to maintain that position in the wake of the following, but the President declared we were at war in 2001. The Congress passed the AUMF, the Authorization for the Use of Military Force, which in a way is a type of, it certainly indicates that there's a conflict going on and they've authorized the use of force by the executive. The Supreme Court implicitly has stated in at least of the 3 or 4 decisions that are called upon as criticism of the Bush administration, which they are, but in those same decisions they've implied that we're at war. Because they've talked about, war doesn't give the executive carte blanche. War doesn't mean they can do whatever they want. And then they've gone on to bang them across the knuckles and say, you shouldn't have done it this way. And they do have right to habeas and so forth and so on. But always implicit in those decisions, from O'Connor and Rawson forward, is the fact that we are at war. And in spite of the fact that we're at war, you can't just do anything you want to do. And then you go to the UN activating, if you will, the self-defense clause, and NATO doing the same thing, and Rio doing the same thing, and all these treaties that we're a part of, I think, reinforce the view that we're at war. Now, how long we've been at war would be yet another debate, and that's the example how, at least for me, I like to compartmentalize these issues. And so some would say, well, the war started in 2001, and others say, no, it was when they attacked a warship in Aden, you know, the USS Cole. Well, no, it was when they attacked the 2 embassies, and we go back to 1998 now, and there was a fatwa in 1998 where Osama bin Laden talked about, I just remembered that, and she didn't make any signals to me or raise her hand, but I know she's saying, don't talk so fast. Don't talk so fast, because I do tend to do that, and I'm sorry about that. But anyway, back to my rapid rate of speech. In 1998, they issued a fatwa that targeted Americans and American civilians. Said, we're going to kill civilians wherever we can find them. You know, what better statement of we're not going to comply with the laws of war, the laws of armed conflict. We don't care what international law says. We're literally going to target civilians. Plus the bombings of the embassies. And back to 96, what happened in 96? He issued a fatwa in 96, all right? You know, saying, you know, again, against Americans. Now, you know, I don't think anybody in the United States, with probably rare exceptions, understood or realized that we were at war all that time. And maybe they're correct, that we didn't really start to have a conflict and a state of war between ourselves and al-Qaeda until 2001. And some would argue that in 1993, with the first World Trade Center bombing, that was an indication that we were at war. So I don't have an answer. I can't really fall down on one of those or the other, so it's worthy of discussion, but I don't have any doubt in my mind that we're at war, and that justifies certain things that flow from that we are at war. Did the administration articulate that very well? No, they did not. One of the most important things that flows from the state of war is the ability and the authority and the right, if you will, to detain people that you capture on the battlefield. And for these purposes, I would confine myself to those people that were captured on a battlefield, not to the people that were captured in Bosnia and brought to Afghanistan or brought somewhere else. Okay, those are all issues that are different. They're not a part of the subset of capturing people on the battlefield. But people that are captured on a battlefield, I always like to boil the law down, and I'm going to do it twice today, to boil the law down to real simple components for non-lawyers, which is what I dealt with most of the time when I was in the service, because we were responsible, Michael and I and lots of others, with training soldiers all the way down to corporals and privates on the rules of engagement, on the Geneva Convention obligations that they have. They're trained annually for at least an hour on these subjects. They don't like it much because most people get up there and they're not very experienced, and they just, you know, read some claptrap from a book or some prepared document for this is what you got to know about the law of war. But innovative people like Professor Newton and others really try to make it live for soldiers and make them understand and come to grips with the training that they're undergoing for their responsibilities under the law of war. One of the ways they do that is to say, look, it's a contract. All this started developing really in the 19th century with the first Geneva Convention in mid-century. And what it is a contract where instead of, as was the course for hundreds of years in war, making war even more ugly than it is today, you just execute people on the battlefield. You know, you don't have to worry about taking care of them or treating them medically or helping them survive their wounds. You just go around and execute them on the battlefield. And international law, you know, had been moving in the direction for a while, but the mid-19th century is really what brought it to a head, and they got together in Geneva and came up with the convention, the first convention. And it boils down to this contract. Do not execute them. Take care of them. Treat them with respect. This will cause them to be willing to surrender, because if you think they're going to execute you anyway, you might as well fight to the death. So there are more casualties on both sides, and this is essentially what underwrites the Convention against for the care of the sick and wounded. All right? And so on the one hand, go ahead and surrender, and you won't be executed. And on the other hand, capture them, and you can keep them until the war is over. You do not have to give them back. You do not have to put them in a situation where they can attack you again or fight you again. That's the essence of that convention. Not once did anybody in the Bush administration articulate to the public the fact that in 1944 there were more than 400,000 German and Italian detainees, if you will, although I'll grant you they had prisoner of war status, and we contend that the detainees from Afghanistan do not have prisoner of war status. Another discussion. There were over 400,000 of these people in the United States, on military installations in the United States. None of them demanded a lawyer. None of them demanded a trial. All of them understood that under the Geneva Conventions, they would be detained until the war was over. And you might imagine that in December of 1944, they were thinking as the Allies were moving across Europe that they might be out by the springtime. And that after the December 16th attack by the Germans in the counteroffensive in the Ardennes, I suspect that some of them at Fort Huachuca or Fort Leavenworth or some of the posts that aren't posts anymore in the United States were talking about it and saying, you know, if that SOB Hitler gets those troops all the way to Antwerp, we may be here for 3 or 4 more years if he splits the Allies. And so it was very uncertain in December of 1944 and January of 1945 as to how long they were going to be detained. Not once did anybody in the administration in 2002 and 2003 articulate that as this is why we're detaining these people. And there could be another debate about whether they were apposite, you know, because they were prisoners of war in 1944 and we were contending these people are enemy combatants. But the great mass of American people didn't understand there was even a basis for detaining people and not being concerned about trials. You just detain them until the war is over. How do you define the war is over? Oh, that's another debate. Let's have that debate. But instead, we're debating the right to speedy trial and whether it should be Article 3 and domestic criminal law principles. Those weren't the debates that we should be having. And this, again, is a failure of the administration. The debate was on the wrong terms. Perhaps more telling, they did not use the example of the Americans, one of them now a senator, captured in the 60s and 70s, detained in North Vietnam by a state that was not even a signatory to the Geneva Conventions, one of only 8 at the time that wasn't a signatory to the Geneva Conventions, who claimed that all of the people they captured were war criminals. The United States government was very clear and consistent the entire time that those men were detained in North Vietnam. And the position was this: you got them, you take care of them in accordance with the Geneva Conventions. And when the war is over, however we define that, then we expect you to give them back to us. The United States government never said, hey, give them back to us now, this isn't fair. Hey, you can't detain them without a trial. That's wrong. What about their right to a lawyer? Not one time did the United States government take that position. And yet we never heard anybody in 2002 and 2003 try to educate the public as to, in the wake of all this criticism about detention and not trials and how can you hold people this long as though they were common criminals from, you know, downtown Cleveland or Toledo or Cincinnati or Dayton. No. Nobody ever articulated the fact that, wait a minute, we're at war. We have the right to detain. We detain until the war is over. There are discussions that we should have, though, because now it is the 21st century and we have this really unusual set of non-state actors that are unprecedented in their economic power and unprecedented in their ability to conduct military operations. So how are we going to tell when the war is over? There's not a capital to capture. There's not really even a head of state to say, okay, yeah, we capitulate, we won't fight anymore. You know, so these are problems. These are things that need to be debated. But instead, we're debating why we're holding somebody until a war that we can't tell when it's over. We're talking about whether they have a right to a lawyer. Why did this happen? It's worthy of another discussion, but I'll say 2 words: arrogance and naivete. I believe that certain people in the administration, certainly not all of them, certain people in the administration were arrogant about the power of the executive, and they were naive in not understanding that the American public needs information. They need to be educated, and I don't mean that in terms of talking down to them. I mean in terms of you need to justify the actions you're taking. If you explain it to the American public, they may understand it and buy into it. But if you just assume that they don't have a need to know, that we know everything, and we can handle this, and all you got to do is follow along, that was their mistake. Arrogance and naivete led them to the mistake, and the huge mistake was the lack of public education, the lack of public diplomacy, both at home and abroad. The second big mistake they made, and it actually occurred before the first one, they did not conduct Article 5 tribunals in Afghanistan. Huge mistake, and we've been paying for it ever since. There was not a single uniformed lawyer in any of the 5 military services that was opposed to conducting Article 5 tribunals. We do them as a matter of course. The Third Geneva Convention says that where there's doubt as to the status, whether the person's a prisoner of war or a civilian or arguably by the United States government, an unlawful combatant or an unprivileged belligerent, where there's some doubt about that, then you must conduct an Article 5 tribunal to determine what their status is. The government got it partly right in that if there isn't any doubt, you don't have to conduct a tribunal. You don't have to do them just for the heck of it. But where there's any doubt, you need to conduct a tribunal. And the decision was made from very high in the government, we're not doing Article 5 tribunals. I personally think that was because they didn't understand the Geneva Conventions. I think personally it was because they didn't care about what they would call derogatorily the international community. I think they felt that it somehow invoked the Geneva Conventions, which quite frankly it should have. Some of them were maintaining the Geneva Conventions don't apply because of the nature of al-Qaeda and the Taliban. All of that was wrong-headed. All they had to say was Afghanistan's a signatory to the Geneva Conventions, the United States is a signatory, we're in that country, we're fighting a war, we're capturing people, the Geneva Conventions apply. When you apply the Geneva Conventions, you need to make determinations as to what is the status of the people that you capture. If it's very clear that they're unlawful combatants, as almost everybody that would be an al-Qaeda member, I'm not going to get into how you can tell they're an al-Qaeda member, but everybody who's an al-Qaeda member is an unlawful combatant, okay, fine. You don't have to conduct an Article 5 tribunal. Taliban is a tougher question. I know that the academics in the room know exactly what I'm talking about, that they may be a ragtag, halfway military. They may not wear the indicia of rank, and they may not train in the law of war. In fact, they say they're going to disobey the law of war and attack civilians and all of that. But still, as ragtag as they are the army of Afghanistan, and Afghanistan is a signatory. And they're going to be right, and you're going to be right. And law review articles for the next 20 years about whether the Taliban were automatically should have been considered, unlawful combatants or not. Okay, that's one for the ages to debate, and both sides have got something to say. But to categorize everybody that they capture as automatically Taliban or al-Qaeda, and not to conduct any Article 5 tribunals, meant that we had this process of evacuating people to different detention places and ultimately sending over 800 over time back to Guantanamo. There's 2 reasons why Article 5s are important to conduct. And one is to comply with the Geneva Conventions and to make sure that, if there's a basis for capturing, that you understand what it is, and to give them an opportunity to say, hey, I'm not Taliban, I'm not al-Qaeda. And in my view, the bar is very low for where there's doubt. The Geneva Convention says where doubt, Article 5, where there's doubt, then you have to have the tribunal. And in my way of thinking, as soon as somebody says, I'm not al-Qaeda, I'm not Taliban, they've jumped over the bar, and you must conduct a tribunal. That's all it takes. Even if the evidence is overwhelming at that time to the individual, you must conduct a tribunal. Conducting the tribunals comply with the law of war, comply with the Third Geneva Convention, but they also, as many aspects of the law of war do, provide a systemic control measure for the military forces. Had we been conducting Article 5 tribunals, we would have had a sense of what kind of things are happening at the point of capture. Are prisoners being abused at the point of capture? Are they being wounded there? What's happening in our process? How are we treating them as we're bringing them back? Are we asking people, who they are? Are we using translators? All those things. So you have an internal control measure, so to speak, on the military force. In much the same way that to comply with the Hague Convention that talks about ammunition and weapon systems that are illegal, the United States Army will not allow anybody to take their personal weapon to a combat zone. Hey, I got a .357 Magnum. I'd rather have that with me. I don't like the 9 mil that you give me. I want my own .357 Magnum. Most people don't know that the reason that we have to have all of our weapon systems and all of our ammunition certified by the Judge Advocate General of the Army before we're allowed to take them anywhere in the world and use them is so that we will comply with the Hague Conventions against unlawful ammo and unlawful weapons. And so because we can't vouch for everybody's private weapon and ammo, we don't let them take them. It's a simple control measure. Could we set up a system and provide the right to take your weapon where we would examine it and look at it before you get deployed? Yeah, we could do that. Why don't we do that? It's inefficient. So we don't do that. So we just say, ipso facto, nobody can take a weapon. And that's an internal control mechanism for our compliance with the law of war, for the government, for the United States nation's compliance with the law of war. And conducting Article 5 tribunals are useful for the purpose I just described, in addition to the fact that you're required to do them by the law of armed conflict. All right, and the third big mistake is, like good lawyers, they took a presidential order from 1942 and they said, this was upheld by the Supreme Court 8-0. We need to get this exactly right. So let's write ourselves a presidential military order just like Roosevelt's. And there wasn't much difference. That's good lawyering. You use what worked. You use what precedent says will be upheld. Of course, Roosevelt's order was based on the 1920 Articles of War, which were superseded by the 1948 Articles of War, which were superseded by the 1950 Uniform Code of Military Justice, which were amended dramatically in 1968, and a little less dramatically, but significantly in 1983. And it ignored 60 years of military jurisprudential development and case law and practice. Other than that, it was a great idea to copy the presidential military order in 1942. And it raises the question also, when we're trying to compartmentalize these issues and make sure that if we're talking detention policy, let's just talk detention policy and what flows from war, and are we at war and how does it end? Okay. And if we're talking interrogation policy, that's completely different. That's a separate category. And so with regard to commissions, the first question that I always want to ask is, why? Why in November of 2001 are we bothering with a presidential order to set up commissions? Other than the Kieran Nazi saboteurs, the Kieran case of 1942, where President Roosevelt ordered a military commission for 8 alleged Nazi saboteurs. Other than that case, there were no other commissions during World War II. Commissions began after the wars were over in May and August. And then there were thousands, 15,000 military commissions after World War II up to 1948. No intelligence issues to speak of. No concern for releasing, intelligence practices and so forth. The war is over, probably a little bit, but not as much as if the war is going on. So why in November are we rushing to do commissions? Why aren't we just kind of kick back? Let's analyze this. Let's look at how would we do commissions in the 21st century. We thought about doing them in Korea, we didn't. We thought about doing them in Vietnam, we didn't. There's 7 articles in the Uniform Code of Military Justice that talk about commissions, but we haven't used them all that time. So let's figure out, we're jumping over 3 statutory changes and 60 years of case law. We ought to figure out what commissions ought to look like in the 21st century. But no, we're going to make them look like they did in 1942. Huge mistake. Huge mistake. And that, in large part, is why we're here today. So with that, a couple minutes late, but I got started a couple minutes late. I'm told that I should open this to questions. So I will. Yes, sir.
Captain Altenberg, we met 4.5 years ago down at Duke at Scott Silverman's. I asked you. Hi, my name's Ben Davis, University of Toledo. We met 4.5 years ago down at Duke at Scott Silverman's thing when I asked you the question about what about Plot E? And you remember at the time you said there's no excuse about Plot E. So here we are 4.5 years later. Isn't it pretty obvious to you the reason that they wanted to go to the military commissions is so they could use basically intelligence gathered against people by means that were obviously completely illegal for under the Uniform Code of Military Justice?
Okay. First of all, I remember you asking that question, and it was especially salient at Duke because, a Romance languages professor down there had just written a book about Plot E. Plot E is a little-known American cemetery in France, adjacent to another cemetery that's open to the public, in which the remains of 95 American soldiers are buried in Plot E. It's locked, and you have to have special permission to go into this special cemetery. Those 95 soldiers were all executed pursuant to court-martial sentence during World War II, either in the European or what we call the Mediterranean theater of operations. There were some 35 that were executed and are buried in the Pacific. And it's separate because the theory of the Battle Monuments Commission is that these dishonored soldiers should not be buried among the honored dead who died in battle. And the book reveals that, obviously, in the mid-40s, in our nation and in our military, racism played a role in which soldiers went to which trials and which soldiers suffered capital punishments. While I think allowed for the fact then, when you asked that question, Mr. Davis, that there were many reasons why they wanted to go to military commissions, the fact is, I don't care why Dick Cheney or David Addington or Jim Haynes or anybody else wanted to do military commissions. I believe military commissions are justified if done correctly. I believe they're a tool in the kit, if you will, of the American government, and in particular the American executive and the commander-in-chief of American forces. And you're entitled to use military commissions because, especially now, they exceed all international law standards. Okay, anything that's being done in ad hoc tribunals anywhere in the world, military commissions as they are now designed, exceed all those standards. And it is important because we're collecting evidence on a battlefield, and there's not, what do they call it, this television program? CSI. CSI is not out there. We're not stretching yellow tape around the place where we just bombed someplace or some kid threw a grenade. We're not doing any of that, and so the evidence is quite different. And so I really don't care about all the bad reasons. And you're right, there were lots of bad reasons. In fact, I likened it at one point in time in a discussion in the Pentagon to, you guys have been watching too many World War II movies, and you got too many ideas. I really personally believe that some people in the administration thought that defense lawyers would roll over. They had no idea of what had happened to military jurisprudence in the last 60 years. They assumed that defense lawyers would do what they thought based on movies and television they had always done, which is, I'll plead my guy guilty. I'm a U.S. Army or I'm a U.S. Air Force officer. I'm not gonna represent a bad guy. All of which was wrong. The biggest shock in the world was when they found, that the defense lawyers were making constitutional motions and opposing the President of the United States. Wasn't a shock to anybody in uniform, I assure you. Either a lawyer or a commander. Nobody was shocked. That's what defense lawyers are supposed to do. They have that obligation. And they do it well, and that's one of the great positive stories of the last few years is the aggressiveness with which the defense lawyers have pursued the representation of their clients, the detainees. So, again, it's the battlefield aspect of it that I think is especially telling. Yes, sir, back there, you're up first.
Thank you for this talk. And on the note you just mentioned, I think Philippe Sand's book makes it very clear that the lawyers of the Judge Advocate General's Corps are really heroes in the struggle of trying to do things correctly. You've carefully limited your, my name is Ken Ludford. I'm a professor of history and law here, and my historical focus is Germany in the 19th and 20th centuries, and particularly legal professions and the rule of law. You've carefully limited the category that you're talking about, category of prisoners, to those captured on the battlefield. And you indicated that your jurisdiction dealt with 25 out of the 700 total detainees, those who had been reported out for military commissions. What role in all of this mistake-making do you think was played by the advanced knowledge that Guantanamo would hold people who got there in different ways? Some from renditions, some from places other than the battlefield in Afghanistan, which, albeit unconventional, looked like a war. that there are different categories of people, and the category you've based your analysis on today is that which most looks like Geneva-type people.
Well, I start by saying something that I'm always quite willing to say, and that is that I don't know, but I'm willing to talk about it. Okay, I don't know the answer to your question, is what I mean.
None of us really do.
But I don't engage in speculation as much as it appears to me that there wasn't a lot of foresight. I think we give the administration too much credit when we think they did this nefariously and they had this all in mind as to how they were going to make all this happen. I personally think that what drove a lot of decision making was their focus on unitary executive. Okay, we can do this, we want to do this, and we want to use this as a vehicle. And I think they were prepared to do that in all kinds of ways before 9/11, and this teed it up for them to use war, quite frankly, for that type of thing. And we've seen it was counterproductive as can be. And in line with what I said about I don't give anybody credit for planning to sort this out the way you've described. I think, they captured a lot of people on the battlefield, and what are we going to do with them? And they're trying to come to grips with how we're going to handle this. And so Guantanamo we've used for years and years and years for refugee operations. It's not like Guantanamo was sitting there as a Sleepy Hollow. In some ways it is. That we've never put people there. We put people from Cuba, the boat people. We put people from Haiti there. We've had thousands and thousands of people in various operations in the 90s where we were using Guantanamo for those purposes. Humanitarian purposes, quite frankly. And there probably were other places that were discussed. They might have discussed Diego Garcia. They might have discussed lots of different places. Afghanistan is so primitive, that it was impractical, I think, to try to do something there in the short term. And so they brought him back to the infamous Camp X-Ray because they just wanted to get him off. Now, were some people thinking they'll be beyond the reach of the courts? Sure, that undoubtedly played into it. In fact, I remember a conversation in 2004 where somebody was arguing against me for what I wanted to do with commissions, and someone said, this was really important to the president. He really thought this was the way this should be, and it had to do with a procedure in the presidential military order, the rather silly one of the commission members can overrule the judge. Everybody remembers that. And this was really important to the president. I remember that he really thought this was important. And this senior executive in the Department of Defense looked at the fellow that said that and fixed him, and he said, "Do you mean to tell me that a decision the president made in 2001 should not be revisited by us regardless of what facts have changed in the intervening 3 years?" And it was, a rhetorical question that was, the guy didn't know what to say. He started blubbering, It's the same person that when I was talking about watching too many World War II movies, many people in government are younger than I am, and I told him that he was reminding me of a Mickey Rooney, Judy Garland movie, It was like, hey, in terms of putting commissions together, it's like, hey, I know what we can do. Let's put on a play in Farmer Brown's barn, and we'll be good, and then we'll go to New York, and somebody will notice us, and in some ways, I very cynically thought that's what they were thinking about commissions. I see some knowing smiles in the room of people who were there at the inception in late 2001 who realized it really was that way. They didn't have a clue. The not-so-apocryphal story of a reserve judge advocate, somebody who wasn't a judge advocate, calling a reserve judge advocate law professor in early November, and it was published on 13 November? In early November, saying, I'm working on this project here in the White House, and I'm told there's a book called The Manual for Courts Martial. Is that right? Could you get me a copy of it? So, yes, sir.
Time for one last question.
Okay.
Okay. If you did hold Article 5 hearings to ascertain whether a person was from Al Qaeda or not, wouldn't it be quite likely that almost nobody would be from Al Qaeda? Because what is Al Qaeda? Al Qaeda means the base. That's pretty nebulous. So it's like, and if almost nobody would be found to be a member of Al Qaeda, couldn't you thus shut down Guantanamo and also these other secret detention facilities all the way around the world.
Okay. Article 5 tribunals would have been conducted on the battlefield in Afghanistan. And you're right to point out that membership, they don't wear something stamped on their forehead that says Al-Qaeda. What you would be determining at an Article 5 tribunal would be, is this person an unlawful combatant or not? So are they a part of an armed force? Were they fighting against us? Did somebody see them shooting and the like? And through questioning, you know, find that out and see what they've got to say. And there would be 3 officers making a judgment about, I think this person is an unlawful combatant. Quite frankly, international law, Geneva Convention 3, Article 5, is vague deliberately by the international community, and it's a very low standard. It does not take much, you know, for someone to be declared, you know, a prisoner of war or an unlawful combatant or a detained civilian. I mean, the standard's very low. I mean, they say what they say, and you drive on. You know, when we talk about the status of people, you know, all these 400,000 people in the United States in 1944, how many, it's a rhetorical question, how many were drivers, typists, clerks, all conscripts? Hey, I don't hate you guys. I didn't want to fight. I didn't even have a damn gun. I was driving a Jeep for the German war machine. And I was conscripted at the age of 17. Why you got me as a prisoner? Because international law says anybody you capture on the battlefield, you keep and you detain. So the first thing I want to say to your question is it would have all happened in Afghanistan, and Justice O'Connor in the Rawson decision basically stomped her foot and winked at the government and said, you know, you should do tribunals. She even talked about some type of status tribunal, which became the Combat Status Review Tribunals, CSRTs, which are years later, Article 5s are supposed to take their place, and which have, quite frankly, much more process, much more protections than Article 5 tribunals. It's a very low bar internationally. And that's another example of what where the government failed in public diplomacy and didn't educate the public as to this is what the standard is. Do you think it's unfair that a driver could be captured in 1944 and kept at Fort Huachuca for indefinite periods of time without a trial, without a charge or anything? And a guy was a 17-year-old driver of a Jeep for a colonel? And the answer is, yeah, that's the law. Sounds bad, doesn't make good television, doesn't play well to the civil libertarians, but that's the law. That's war. War is hell. It's ugly. We're trying to do the best job we can at making it, you know, as humane as possible. But it's an ugly, dirty business to begin with. And so that's got to be the start point. And that's, you know, we were never put on a war footing. The criticisms go on and on about where that takes us. And as George Goebel used to say, not many people remember George Goebel. I see by the clock on the wall, there's a dead fly. I thank you.
Well, almost General Altenberg's last words, the criticisms go on and on and on, and in fact, that's prophetic, because we will continue to critique and to criticize and to debate and to analyze. After a break, we'll resume immediately at 9:45, so enjoy the break. Thank you.